Swayam Prabha. Digital India. Educated India.
So still now we have discussed regarding this abuse of dominant position, and we are talking about the existence versus exercise of this IPR. Then again the per se, as I said, intellectual property right is not hampering the competition, but under certain circumstances the behavior of the intellectual property right holder may lead to abuse of the dominant position. So, in one of this again one of the landmark cases in the Mazel decision, the the court went further and it extended the reading of this Volvo case to the exceptional circumstances test. So, basically this case is about the dealing of Magil, which is a Irish TV programmer. He wanted to compile compile a TV program guide, because there are 3 TV channels which were broadcasting their programs, and they used to come up with a weekly magazine that listed out the various programs, the timing of the various programs. So, Magil decided to have a combined Magil decided to come up with a combined program guide with this 3 TV broadcaster in Ireland. But however, these the 3 companies did not give permission to Mazel to compile their material, the weekly guide, because it was under the purview of the copyright. So, they said it is our copyright, and they did not provide this copyright to the Mazel to come up with a new guide. So, so it in this case particularly the court ruled that the refusal of these Irish TV programs to license their IP protected listing to a company that tried to publish a comprehensive weekly television guide for Ireland, a product that did not exist earlier at the time of the judgment, is abuse of dominant position, because here the court looked into this exceptional circumstances test, and particularly the court looked into 3 requirements. First, is the refusal to this licensing which involved an intellectual property right in the term of a copyright. So, is that refusal needed to prevent is the refusal has led to the led to the if the refusal has prevented the appearance of a new product, that is the weekly TV guide, and if there is sufficient justification for the refusal from the broadcasting or the publishers. And third, is the license is indispensable to enter the downstream process of a making a for market of new TV guides, and which may lead to a monopoly on the secondary market for the protection of the IP right or not. So, these 3 questions were broadly considered by the European Court of Justice to come up with this exceptional circumstances. So, basically in this case what happened, because of this refusal of this license by these 3 broadcasters, it prevented for the development of a new product into the market. So, again the motto of the competition policy in the European Union is to promote more innovation, promote more competition and healthy competition. So, since it prevented the appearance of a new product, which was a weekly TV guide combined, which is contains all this information from the 3 broadcasters, is prohibited because of this refusal to the license. And second, was there a justification for the broadcasting? So the court did not find any suitable justification which for the refusal. And second, was the license was indispensable for creation of a new downstream market or not? So, was the license regarding that copyright was needed to create the new TV guide? Yes, of course, because they have the copyright, the 3 broadcaster had the copyright over the program listing. So, the license was very much essential to come up with a new program guide. So, because they refused the license, so a new kind of type of product was prevented from coming to the market. And it may lead to the monopoly on the secondary market for, because again this new product was dependent on the on the copyright holders. So, they had kind of monopoly in the market. So, again these are the, so basically this court laid this case laid the provision for the basic provision for this exceptional circumstances, means under what circumstances the act or the behavior of the undertakings may lead to abuse of dominant position. And furthering this case, there was another doctrine which is known as the exceptional circumstances doctrine. It was again in the it came up with this IMS Health case in 2004, and so this case was basically about licensing of a thing which is known as the brick structure. So, the IMS Health has in France, it has created a brick structure which is known as the 1860 brick structure. Basically, it divided the whole pharmaceutical market depending on the nature of the cells and the pharmaceutical prescription. So, it made a kind of map or a kind of structure which gave a clear insight to the pharmaceutical manufacturers to understand what kind of sales and what kind of medicine is being sold at various part of the France. So, in this case the certain other companies, two more companies wanted to have had shouted for this license from IMS Health to come out with similar kind of brick structure, so that they would enter in the market, but IMS Health refused to give the license, saying that this is his copyright, and was not willing to share the technology. And further, IMS also said that they are infringing on the technique the IMS is adopting to creation of this pharmaceutical market, pharmaceutical brick structure. But the brick structure was so critical at that point of time, means all the pharmaceutical firms are relying on the brick structure to for their market analysis. So, in this case the exclusive right to reproduction from parts of this copyright holders right, so that a refusal of license cannot in itself constitute an abuse. So, in general refusal of license is not does not constitute an abuse of dominant position. However, again in some exceptional circumstances the refusal may lead to abuse of dominant position or may lead to the abusive conduct. So, again in this case the European Court of Justice ruled that when a copyright holder refuses to give access to a product or service indispensable to carrying out business, this only will be considered as an abuse, where three parameters were taken. First, the undertaking which requested the license intends to offer new products or services not offered by the owner of the copyright and for which there is a potential consumer demand, and the refusal cannot be justified by the objective consideration. Third, the refusal is such as to reverse the undertaking which owns the copyright and the relevant market by eliminating all competition in the market. So, these three conditions were ruled out by European Court of Justice. So, basically so it looks into the circumstances where the intellectual property is very critical for development of a new product or the service, and also it looks into the demand side from the consumer as well, whether there is a potential demand from the consumer side to creation of the new product in this segment or not. And again whether this kind of agreement may lead to elimination of all competition in the market or not. So, these circumstances also should be taken into consideration in deciding the abusive conduct. After the Magill case, one of the important cases in the history of European Competition Commission was this IMS Health case in the year 2004. Basically, this case was about the copyright related protection, and under which circumstances the denial of licensing of copyrighted material can lead to abuse of dominance position. So, basically this case law has given the concept of exceptional circumstances doctrine, or in other words we may say that it has re-emphasized the Magill judgment. So, going to the brief facts of the cases in this IMS Health cases. So, IMS Health basically had a copyright over a particular kind of structure which is known as the brick structure. In this brick structure named as 1860 brick structure, it has divided the total German pharmaceutical market into 1860 bricks like compartments, which basically was developed on the area code, taking the area code into consideration, and it gave the pharmaceutical sales data and the prescription medicine data in those areas. So, this brick structure was important for all the pharmaceutical manufacturers and distributors in the Germany, because it gave them an idea regarding the sales and distribution of the medicine. So, another two companies, NDC and AGX, they wanted to have a license on this copyrighted material from IMS to develop another database which would show the pharmaceutical sales data and pharmaceutical medicine supply information. But however, IMS Health refused to provide the license regarding this copyrighted 1860 brick structure, and this led to filing of a complaint to European Commission regarding the denial of the license from IMS to NDC as well as the AGX. So, first this case was being prosecuted in the German court, as well as simultaneously it was referred to European Court of Justice. So, this case was going side by side in both the two cases. So, here the question was whether the denial of an license by an copyright holder or the intellectual property holder would lead to abuse of dominant position or not. As we already discussed, again re-emphasizing on the fact that the intellectual property right gives an exclusive right to the owner of the intellectual property. So, it is on the discretion of this owner of that property that whether he would like to give the license or not. So, taking into fact of the basic principles of the intellectual property right. But however, when coming to abuse of dominant position, as we said, mere existence of this IPR is not an issue, but how to exercise the intellectual property right, that becomes an issue, and that may lead to abuse of dominant position. So, in this 1860 brick structure, so the court has considered that whether IMS would have the exclusive right to reproduction, it may have the right to refuse the license, or the way it has exercised this exclusive license may in exceptional circumstances can give rise to abusive conduct. So, here again the court has taken into consideration the three-prong approach, where first they have looked into whether the product or service in question is really essential for the development of a new product or a service in the market, whether there are justified conditions for the refusal of this license or not, and whether by refusal the right holder is trying to limit all the competition from the market or not, and he is trying to primarily retain their position and limit all the competition from the market or not. So, here the European Court of Justice considered the particular situation and tried to find out whether this copyrighted brick structure is essential or indispensable for the development of a new product or in a service or not. So, here the 1860 brick structure is a particular kind of a map which provided the pharmaceutical sales data and the pharmaceutical prescription medicine distribution data to the other vendors. So, and the NDC and AGX were trying to sort the license for development of a new kind of brick structure. So, without the permission from this copyright holder, it is not possible on the part of NDC or any other company to get a new database. So, it was held that the copyright in question is really indispensable for the creation of the new product, and can refusal be justified by objective consideration. So, since this brick structure has become a standard in the market and all these pharmaceutical companies were relying on the data of the brick structure, it has set their own standard. So, there was no justification which EC could find in denying the license. And again, if IMS Health is denying this license, then again it is stopping the development of a secondary market. So, basically here the judge also looked into two kinds of market. First one is known as the upstream market, means the 1860 brick structure itself, where it provided the data regarding the pharmaceutical cells and prescription medicines. So, the companies were taking that into consideration and doing their businesses in the Germany. And second is the downstream market, which would be created by licensing of this database structure, where and like companies like NDC or AGX can take the information from the 1860 brick structure and create a new kind of database, may be used for other pharmaceutical segments. So, in this case, by denial of the license of this copyrighted material, IMS Health is indeed retaining its monopolistic power in the market, and in some way it is trying to eliminate all the competition from the market. So, in this case the ECJ decided that yes, it is a under these exceptional circumstances the refusal of license may lead to abuse of dominant position. So, this is one of the landmark decisions, so which laid down a three-pronged approach for determination of the abuse of dominant position after the Mazel judgment. So, there are series of case laws for the article 102, which has laid down the development in the European Commission and how it has looked into abuse of dominant position, which comes under the article 102. Coming next, like one of the important cases in the history of European competition policy is also this Microsoft case. And it has in a way redefined how European competition policy looks into intellectual property as well as abuse of dominant position. The earlier case laws like the Mazel and the IMS, we have seen that like the three-pronged approach has been followed, and they have given the exceptional circumstances under which the behavior of one dominant player can be regarded as abuse of dominant position. So, in the Microsoft case, basically the European Commission look into two aspects. So, there was supposedly abuse of dominant position regarding first regarding the refusal of supply information, and second regarding the tying of two different products. So, going to the brief facts of the cases, the Sun Microsystems basically requested Microsoft to provide the critical interoperability information or the detailed interoperability information for operating its operating system in Microsoft Windows. So, during that time, like this case happened during 1998. So, during that time Microsoft had more than 90% of share in the market, in the operating system market, and it had it has established itself as a de facto standard for client operating systems. So, the Sun Microsystem at that time was like, which is based on a Linux kind of operating system. So, the Windows and the Sun were not compatible. So, in order to operate in the Windows operating system servers as well as the clientele computers, Sun Microsystem required certain critical information by which they can program or they can run in the Windows operating system itself. So, therefore, the Sun wanted to have license or requested Microsoft to give the information regarding the interoperability data. But however, after 4 months the Sun Microsystem complained the European Commission, saying that the Microsoft is abusing its dominant position by denying the access to the interoperability data. So, this led to the investigation by the European Commission in 1998, and the first decision came in 2004, in which the European Commission said that the Microsoft indeed is abusing its dominant position, and this abuse is being done by two ways. First, the abuse by denying or refusing to supply information to Sun Microsystems, and which is initiated by the complaint by the Sun Microsystem, and the second abuse is by tying two products, like Windows has Windows Media Player in with all the client operating system along with the Windows. So, with its own investigation, the European Commission found that the Microsoft is trying to tie two different products and it is selling it in the market. So, so in the judgment, the court has looked into these two aspects in different manners. So, we will just discuss that about that. So, going to the first instance where it was said that the Microsoft has abused its dominant position by refusing to supply the critical information to Sun Microsystem. So, basically the refusal to supply case was about the computer networks that link the client computers used by the employees for their daily works with the server computers that perform the specialized tasks, including the including managing network, printing of material or transferring of data. So, so the question which the commission considered is whether the information requested by Sun was indeed needed by the rival server operating system vendors to enable their work group server operating system to interoperate with the Microsoft client computers as well as Microsoft work group server operating system in the same network or not. Means whether the interoperability data is critical for operation of the Sun Microsystem or any other competing company or not. So, in this case the court of first instance actually decided the European Commission concluded that yes, this was the interoperability data is essential for functioning of the other thing for the operation of the other competitors, and in this regard the Microsoft is abusing its dominant position. So, the European Commission has directed Microsoft to license this interoperability or provide the critical information at a reasonable, fair, reasonable and non-discriminatory terms, like which now we know as the FRAND terms. But again there were it was not readily, the Microsoft did not agree to it readily, and three conditions were laid, and this led to another investigation later on. So, finally, the Microsoft agreed to license the protocols at three different terms. However, if you look critically into the decision, the court has again followed the same path as in the Mazel judgment or the IMS or the Bronner case, and it tried to find out or try to lay down the condition required by a company to like whether the product or service in question is really indispensable for carrying out the competitor's business or not. So, as we know in the Mazel case, the TV program listing, which is TV channel listing by BBC or the other RT and other player, is really critical for Mazel to come out with a weekly guide for the customers. So, here in the Mazel judgment, the weekly TV guide was the new product in question, and the copyrighted material by these three broadcaster company were really essential for the formation of this weekly guide. So, because they denied to supply the information, Mazel could not develop a new product. And similarly, in the Bronner case, which does not directly relate to intellectual property, but there also the court has looked into the question of the indispensable service, where Bronner like tried to associate with the Media Print, who was the leading supplier of the newspaper in that region, and had a home delivery system, and Bronner wanted to get involved in the home delivery system, so that the newspaper can be home delivered to the customers. There the court looked into the question that whether the product or the service in question is really indispensable for carrying out business of the competitor company or not. So, like the newspaper distribution system, like the home delivery system of newspaper is not a single way by which the newspaper can be delivered to the consumers. Like it may be delivered through shops or by post offices or by other means also. So, here in that case the court has decided that because this service in question is not indispensable for the business of this competitor firm. So, it is the denial of the license or denial to tie it with or tag it with Bronner is not abuse of dominant position in case of the media print from the point of media print. So, similarly, in IMS case as we discussed, the 1860 brick structure was really critical for development of a new pharmaceutical market map. So, that is also stopping if because of the denial of the license production like generation of a secondary or downstream market is being stopped, as well as the IMS is having a leading position in the upstream market, and it is it may indeed stop the competition in the European Union. So, in all these three cases, so like it was clear that a necessary condition for requiring a company to share its property is that the property itself be indispensable for carrying out the business other person's business, inasmuch as there is no actual or potential substitute in existence. So, the indispensable nature of the property is really essential to find out whether there is abuse or not. However, in this case the property may be any property, may be intellectual property or any other kind of property. However, in the Microsoft case also the court looked into whether the interoperability data by Microsoft is really indispensable on the part of Sun Microsystem or any other competing microsystem or not, because the Sun Microsystem and others operated in a different operating system. So, yes, it was essential to and this interoperability code, there is a codec and they are all technical things. So, that was also required by Sun Microsystem, without which Sun Microsystem cannot enter into or cannot operate in the Windows operating system. So, the court ruled that yes, this the interoperability data was indeed indispensable, and for that reason this refusal to supply the information is is a behavior is a kind of abuse of the dominant position. And in the second case, the tying case, in generally the tying is like association of the two different products, where one company tries to sell or forcefully sell one product, the complementary or the other product with the main product. So, here the European Commission found that the Microsoft is selling the computers for the client operating system particularly with the media playback software that is known as the Windows Media Player or WMP, which enables the computers to play back audio as well as to play back the audio as well as the video content. So, during that time there were separate like streaming video, there is separate software for streaming the audio from the radio or streaming the videos from the other sources, but with the advent of the broadband during the late 90s, the Windows has come up with this Windows Media Player software, which can play back directly from the server the audio as well as the video. So, there were other players also, there are Realtek and other systems there in place, which was also doing that kind of business, but during this case it was Microsoft was the one of the leading company who has developed this Windows Media Player system, and Microsoft has started selling the Windows Media Player system along with this Microsoft operating system. So, the Commission's concern was that given that the window was more than 90% of all the PCs, the bundling of Windows and Windows Media Player guarantees that Microsoft Windows Media Player is unique or has the unique position in the market. So, because so in this case basically the court looked that whether like basically in that all the tying cases we look into that whether these two products in questions are really inseparable or are they separate object or not. So, this is one of the question, and again like what will be the consequence if the company tries to sell or complement the product together. So, as per this commission found that Microsoft had abused its dominant position in the client operating system by making its client operating system available only with its media player since May 1999. First, so this has started since May 1999. So, basically the commission did not have object to Microsoft's making Windows available for the Windows Media Player, but it objected to Microsoft's making Windows available with this WMP without also making available Windows without Windows Media Player. Means from 1999 onwards it started selling the Windows operating system along with the WMP also. Earlier both WMP were available separately, Windows operating system was also available separately, but this bundling which started after May 99 led to the question of tying up. So, after this prosecution of this case, the commission ordered the Microsoft to make available a version of Windows that did not include Windows Media Player, and it prohibited Microsoft from charging more than the unbundled version of the Windows than for the bundled version, but again it did not require the Microsoft to charge less for the unbundled than the bundled version. So, so there are many criticism basically for this case. So we will just discuss in this in context of this 2 point, like refusal to supply the information as well as the tying. The criticism was that in the first instance in the IMS case, IMS health case or the Mazil case, basically the court looked into the 4-pronged test approach, where it looked into whether the denial of supplying the information is leading to stopping the development of a new product or not. So, the new product condition was satisfied in both the IMS health as well as the Mazil case, but in the in this Microsoft case, the new product is per se is not, the question of new product per se is not addressed, because the Sun Microsystem was also having during the case during the time when the case was filed, the Sun Microsystem was also having nearly 60% market share in the open operating systems, and in these Windows operating system, like it has the Windows has gradually increasing the market, Windows is getting the market share more rapidly, but when while the decision was being taken place, like Sun Microsystem had nearly 12% of the share in the market, and it is not that because, so there is no question of a new product. Yes, Sun Microsystem wanted to operate within the area of Windows operating system, but the refusal of license per se is not prohibiting Sun Microsystem in operating in the market, because it has limited share, though the number of shares were less, but again it was existed in the market. So, here there was no question of the new product. So, but in this case the court held that the circumstance relating to the appearance of a new product as envisaged in Mazil and IMS health cannot be only the sole parameter which determines whether a refusal of license to an intellectual property right is capable of causing prejudice to the customer within the meaning of the Article 102 of this Treaty of Functioning of European Union. Further, the CFI added that it was sufficient for the Commission to prove that the refusal to supply interoperability information gave rise to the limitation of technical development. So, in this judgment, it was the first landmark judgment where the new product has been substituted with the technical development. So, according to some according to some critics of this judgment, they said that it would be quite vague for the intellectual property right, because intellectual property right anyway is like there for promoting the technical development, and again the exclusivity of the intellectual property rights gives the right of monopoly to the inventor. So, by just denying the technical innovation or technical development, saying that it is abuse of dominant power is really not justified. And again the European Union is like the behavior of the dominant position, behavior of a dominant firm is per se in the European policy, the dominant behavior of a dominant firm or the refusal of a license by a dominant firm is per se taken as the abuse of dominant position, which is again highly criticized. So, so this was the first one. And coming to the second case where Microsoft was held Microsoft was held tying Windows Media Player to the Windows operating system. So, basically it also came from the court in this case also followed the judgment from this Hilti and the Tetra Pak case, where like in the Hilti case where the supplier tried to sell construction material, these some of this binding material used in the construction along with selling with the nails used for that. So, basically they denied to sell the construction what you say is they denied to sell the substance to without to the customer who is not buying the second product. So, like they tried to sell both the products, they tried to sell the first product only in the condition that the customer is taking the second product or not, and they said that these there is basically what you say is again in the Tetra Pak case, basically which was consisting of a packaging machine which used for the packaging of the antiseptics, and there the Tetra Pak complemented the product along with the Tetra Pak which is manufactured by this company itself. So, in both the cases, so it was saying that the substances which are being sold were complemented or are two different products. So, again taking the lead from those judgment, the EC has said that EC hold that the tying was subject to a per se condition, per se prohibition condition under the European Commission law, and it is triggered by finding of the dominance in the market for the tying product, the establishment of the tying product and the tied product as the two separate products. So, first it tries to establish the dominant market for the tying product, and then whether these two products are separate or not, and then also it looks into whether any element of coercion towards the customer is used or not, means the customers are forcefully are forced to take this two product or not. So, this approach in European Union basically it differed from the United States in this aspect, because in European Union the per se rule of illegality is given importance rather than the rule of reason approach. So, like in under this European Commission, the tying under the EC law is closer to a strong per se rule of illegality, means a dominant firm commits an abuse if it requires the consumer to take another product as a condition of taking its dominant position and is commercially successful. So, here like if a dominant firm is commercially successful and it is tying one product with the first thing is per se considered as the illegal, whereas in US it looks into the more economic approach and considered what may, like from a consumer point of view as well as from the manufacturer point of view, it looks into like is there any economic significance of this tying or not, like what effect does it have on the consumer market or consumer psyche, what options do the consumer, like is it beneficial for the consumer or not. So, Europe in United States it not only looks into the competition in the market per se, but also looks the approach approach from the consumer itself. But the European Commission differs in this respect from United States, like it is looking into the more static influence, like we discussed about the static and dynamic innovations. So, static innovation which talks about the difference in the pricing, and dynamic innovation is like more relatable to the technical development. So, here instead of looking into the more dynamic approach, the European Commission has looked into more static approach. So, so this case is like one of the critical cases in the history of European Commission, because in this case really it has blurred the line between abuse of dominant position and the tying, means article 101 and article 102 itself also. And particularly in the case in the cases where the intellectual property rights are concerned, like how to judge this new product or new innovation or stopping of a technical innovation, and again the behavior of the competitors in the market, like these approaches have been like the quite like this judgment gave a little bit of different approach, which not liberal per se. Again like some critics say that like European Commission follows an approach where no market per se can have a dominant position, like if it has a majority of the shares, till then the European Commission's policy is like such that like it will never allow any market to get a dominant position. So, this was all about article 101 and article 102. So, in the next sessions we will discuss about the various provisions given by European Commission, like this exemptions, or what is the block exemptions, particularly the free space where the companies can operate, and what are these how this guideline has been placed successfully. So, with that we end this session on 101 and 102. So, thank you.